Government court rules MetaBirkin NFTs entitled to First Amendment protection in Hermès trademark case.
In one of the primary brand name cases including NFTs, non-fungible tokens, the U.S. Region Court for the Southern District of New York's perspective in Hermès International, et al. v. Artisan Rothschild reveals new insight into how courts could survey brand name privileges regarding NFTs and computerized items. Hermès, proprietor of the well-known Birkin brand name for extravagant satchels, sued Mason Rothschild for brand name encroachment after he made and sold NFTs of advanced pictures of fuzzy toads, which he called MetaBirkins. The MetaBirkin NFTs sold at costs practically identical to Hermès Birkin purses, i.e., a huge number of dollars.
Strikingly, Rothschild had supposedly recently depicted the packs as an accolade for Hermès' most renowned sack, the Birkin, and expressed that he needed to check whether he could make a similar sort of deception as the actual Birkin packs with the MetaBirkin NFTs. Hermès additionally submitted proof that the media and buyers the same erroneously accepted that the MetaBirkin NFTs were really connected with Hermès. Rothschild moved to excuse Hermès' altered grumbling for inability to express a case, contending that Hermès couldn't win as an issue of regulation because of First Amendment assurances stood to fine art under Rogers v. Grimaldi, 875 F.2d 994, 2 DCIR 1989. Under Rogers, a craftsman's First Amendment freedoms basically trump a brand name proprietor's privileges to forestall the utilization of its imprint in the title of a fine art except if the title has no creative importance to the hidden work at all, or on the other hand, on the off chance that it has some imaginative significance, except if the title unequivocally misdirects regarding the source or the substance of the work. Resulting case regulation extended the Rogers test to any reserve claims against expressive works, i.e., past utilization of an imprint in the title. Hermès, then again, contended that the offer of NFTs was absolutely business, implying that Rogers was irrelevant, and the customary probability of disarray test ought to apply to decide if Rothschild's utilization of MetaBirkin encroached Hermès' brand name freedoms. Hence, the central point of contention under the watchful eye of the court was whether the MetaBirkin NFTs ought to be treated as expressive works, by which the NFTs just confirm responsibility for fine art, which require the offsetting of brand name freedoms with First Amendment privileges under Rogers, or 2 non-expressive business items, which call for utilization of the Second Circuit's standard Polaroid probability of disarray test. Observing that Rothschild's MetaBirkins were computerized pictures equipped for comprising a type of creative articulation, the court held that the pictures were qualified for First Amendment insurance and accordingly applied Rogers. Notwithstanding, the court denied Rothschild's movement to excuse in light of the fact that Hermès adequately claimed that Rothschild's utilization of MetaBirkins either has no imaginative significance to the fundamental work at all, or, regardless of whether it has some creative pertinence, it unequivocally deludes concerning the source or the substance of the work. That's what the court noticed. In surveying that unequivocally deceptive prong, it ought to focus on the standard Polaroid elements to evaluate whether there is a probability of disarray, yet that any probability of disarray should be adequately convincing to offset the public interest in free articulation. This choice reveals new insight into how courts in later cases could treat the offer of NFTs and computerized/virtual items in the metaverse in two huge ways. In the first place, the court was not convinced that the utilization of NFTs regarding the MetaBirkin computerized pictures delivered the deal business to such an extent that the First Amendment shouldn't matter. Rather, it noted NFTs are just code highlighting the area of advanced pictures, which are safeguarded by the First Amendment, and confirming the pictures, and utilizing NFTs to verify a picture and take into account detectable resulting resale and move doesn't make the picture an item without First Amendment insurance. Anything else than selling numbered duplicates of actual artworks would make the artistic creations wares for reasons for Rogers. Accordingly, simply connecting an NFT to a generally expressive work may not be adequate to overcome the utilization of Rogers' First Amendment securities when outsider brand names are utilized in expressive works or their titles. Second, the court expressed in a reference that Rogers probably won't matter assuming the NFTs were joined to a computerized record of a basically wearable Birkin purse, in which case the MetaBirkin's imprint would allude to a non-discourse business item. Here, Hermès' grievance didn't adequately charge that Rothschild was really selling essentially wearable packs under the MetaBirkin mark, nor that he would do as such in the prompt not-so-distant future. This is especially outstanding for brand proprietors looking to implement brand name privileges against virtual items, i.e., that are wearable and usable by symbols in the metaverse, bearing confusingly comparative imprints. Finally, the court noticed that the offended party's extra cases for brand name weakening and cybersquatting will rise and fall with the First Amendment safeguard to the brand name encroachment claims and the use of the Rogers test. While each case will turn on its own realities, Hermès gives an accommodating starting direction to possible defendants concerning how a court might authorize brand name freedoms against virtual merchandise in the metaverse and the utilization of NFTs regarding the offer of advanced resources.